Welcome to Sentencing of Indigenous Offenders, presented by Group I, Owen Maguire, Renee Marshall, Emma Robinson, and Maddie Robinson. Over the past 3 decades, 2 inquiries have been launched into the involvement and interaction of Indigenous people within the criminal justice system: the 1991 Royal Commission into Aboriginal Deaths in Custody and the 2018 inquiry into the incarceration rate of Aboriginal and Torres Strait Islander peoples. Although criminal justice reforms have been implemented in response to the recommendations from the Royal Commission, the gap between Indigenous and non-Indigenous incarceration continues to widen. This presentation will look at changes that have been implemented since the Royal Commission, in addition to the ongoing issues of intergenerational trauma and the causes of Indigenous criminality, the effectiveness of Indigenous courts, ongoing Aboriginal deaths in custody, and cultural impacts, in order to provide recommendations for further improvements regarding Aboriginality as a mitigating factor in sentencing.
Aboriginal people are vastly overrepresented within the criminal justice system. Although Indigenous Australians make up only 3.8% of the Australian population, in 2021-2022 they were 14 times more likely to be in prison than non-Indigenous people. Due to many Aboriginal people entering the criminal justice system in their teens, it is vital that all sentencing options, such as diversion programs, be implemented before incarceration is considered. Many of these teens have been involved within family services before entering the criminal justice system. Koori courts have been successfully helping Aboriginal people with sentencing outcomes for over 20 years. Many diversion programs can be used in sentencing, helping many Aboriginal people. In 1992, a New South Wales judge, Judge Woods, related 8 common law recommendations for sentencing Aboriginal offenders. These are known as the Ferrando Principles. They consider the breakdown of Aboriginal families, intergenerational offending, and disadvantages that are evident in a lot of Aboriginal communities. While sentencing principles should be non-discriminatory, it is crucial that consideration that Aboriginal people may come from disadvantaged backgrounds plagued by intergenerational trauma and factors into the sentencing outcome. The final report from the Royal Commission identified the link between the high levels of disadvantage suffered by Indigenous Australians and their overrepresentation in the criminal justice system. To rectify the issue, the Royal Commission proposed 339 recommendations, identifying that the underlying and driving of Indigenous disadvantage would need to be addressed while concurrently reforming the criminal justice system programs and practices. More recently, in 2018, the Australian Law Reform Commission conducted an inquiry into the incarceration rate of Aboriginal and Torres Strait Islander people, making a further 35 recommendations to address the issue.
To achieve fairness in the criminal justice system for Aboriginal offenders, several recommendations should be followed. Judicial officers must be trained to understand the lasting impacts of colonisation, historical factors and cultural factors that influence Aboriginal behaviours. Programs that repair harm, restore relationships and promote rehabilitation should be enforced. These programs are rooted in the Aboriginal cultural practices and align with traditional Indigenous values. Aboriginal elders and community leaders should be integrated into the criminal justice process to provide cultural knowledge and insight into the offender's background. A trauma-informed approach to sentencing should be developed that recognises the impact of intergenerational trauma on individuals' backgrounds and behaviours. Community-led rehabilitation programs that acknowledge the challenges faced by Aboriginal communities should be invested. Policy reforms should be addressing systemic issues contributing to the overrepresentation of Aboriginal individuals in the criminal justice system, includes examining and reforming laws that may disproportionately affect individual communities and addressing racism within the law enforcement and legal system. Fostering these elements creates a more just and culturally sensitive approach to sentencing Aboriginal offenders. It is essential to consider the impact of intergenerational trauma, which is a complex issue that significantly affects the lives of individuals and communities.
Many of the recommendations from the Royal Commission into Aboriginal Deaths in Custody urged police, courts and the correctional services system to consult with and be more culturally appropriate for Aboriginal people. Variations of Indigenous community courts are operational in all states and territories excluding Tasmania. Prior to the establishment of Indigenous community courts, traditional courts were perceived as alienating for Indigenous offenders. Community courts, such as Victoria's Koori Courts, intend to involve Aboriginal elders and respected persons in sanctioning unacceptable behaviour, as it is more appropriate and possibly more effective for Indigenous persons than traditional approaches. A 2010 evaluation of the Queensland Murray Courts observed the court's success in improving relationships between Indigenous communities and the Queensland Magistrates Court. Further, the study found an increase in court appearance rates and participation with rehabilitative services, and the court initiative was valued amongst Indigenous community stakeholders. Additionally, a 2011 evaluation of the Koori Court pilot program found that it influenced offender behaviour as they felt shame and responsibility for their actions, and were more motivated and supported to address their offending behaviour. Finding that the evidence from the pilot program clearly demonstrated that the Koori Court system improved Indigenous offenders' experiences within the criminal justice system through the provision of a culturally appropriate court setting, process, and involvement of elders and community members in the court. Lastly, it was found that including the accused offender in the sentencing conversation gave them a sense of ownership over their sentence.
In 1991, the final report of the Royal Commission into Aboriginal Deaths in Custody found that while Aboriginal people were more likely to die in custody than non-Aboriginal people, they were also considerably more likely to be imprisoned than non-Aboriginal Australians. The Royal Commission was initially set up not only due to concerns about the number of Aboriginal deaths in custody, but also the number of Aboriginal people in custody. The National Deaths in Custody program was set up in response to the recommendations of the Royal Commission and now has over 30 years of statistics available regarding deaths in custody. Since the Royal Commission into Aboriginal deaths in custody, over 561 Aboriginal people have died in police custody, including in watchhouses, police stations or prisons. Out of the 10 deaths in custody reported in 2020-2021, half of the Aboriginal deaths in custody were from natural causes. If Aboriginality were used as a migrating factor in sentencings, these numbers may decrease as the overall population of Aboriginal people in custody would also decline. There have been many reported cases, such as Miss Doon and Tanya Day, where Aboriginal people have died in police custody while being held for minor infringements. Without better sentencing outcomes for Aboriginal people, statistics show that Aboriginal deaths in custody will continue at a high rate.
As far as cultures go, mainstream Australian culture and Aboriginal cultures have roots which are perhaps as vastly different as could be possible. Since the earliest New South Wales Supreme Court decisions in the 1830s, the common law has renounced Indigenous societies and their laws. This lack of cultural appreciation, respect, and understanding has contributed to the over-policing and over-representation of Indigenous Australians in our legal system. Creating any legal system which favours one culture group over another is bound to cause problems. However, Canada, a similar country to Australia with a colonial past, in 1999 had Supreme Court judges which stated that they should place a new emphasis upon decreasing the use of incarceration when sentencing Indigenous offenders. Although not explicitly stated, this is establishing Aboriginality as a mitigating factor, which has already recently begun to steadily reduce their imprisonment rate in Canada. Currently, the Australian Aboriginal incarceration rate is 14 times that of the mainstream population, while in Canada it is 9 times. While still high, it is a great improvement over the current situation in Australia.
In summary, despite reforms to the criminal justice system since 1991 Royal Commission, the gap between Indigenous and non-Indigenous incarceration rates has continued to widen. We must take immediate action to address this issue. This includes recognising Aboriginality as a mitigating factor in sentencing, addressing intergenerational trauma, and improving the effectiveness of Indigenous courts. Achieving lasting change will require collaboration between communities, policymakers, and law enforcement. We must remain vigilant and implement transparent monitoring measures to enforce reform and establish a fair and just criminal justice system that values Indigenous perspectives.
We propose the following 3 recommendations. 1. Australian and Commonwealth legislation should include special consideration for the sentencing of Aboriginal and Torres Strait Islander offenders in order to account for the systemic and background factors which uniquely affect those people. 2. Commonwealth, state and territory governments should remove legislation which impose harsh mandatory sentences, as Indigenous Australians are disproportionately affected by such sentences. 3. Information from the Indigenous community court decisions and discussions should be made publicly available and readily accessible to inform non-Indigenous Australians, promote acceptance and cohesion, and to ensure accountability and transparency.